to you our webinar today on legal and business issues concerning the COVID-19 virus. I want to thank you all for being involved on this call. I understand that we have almost 500 people who are going to be on the call today. Some housekeeping tips before we get started. This is being recorded and we will post it on our website, which is gunster.com/COVID-19. And it's a resource page, and we'll let folks watch this on demand after we conclude today. And you will have the opportunity also to share it with others. You will be able to submit questions using the question and answer feature on your screen throughout the presentation. Questions will be sorted, read aloud anonymously, and answered by the most appropriate attorney. We're going to begin our presentation here, and I wanted to just say that we're really thankful to Representative Davis for allowing us to do this presentation with the Jacks Chamber today. And I want to say on behalf of the Gunster law firm and my colleague Bill Perry, who's our managing shareholder, that we know how important the role that all of you are playing is for this state, for your region, for our country. We have to keep working. It's very important that we continue to provide services and goods in the marketplace, and that we continue to employ our employees as we go through this difficult time. We've never experienced anything like this, but we are going to get through it, I assure you. And the steps that have been taken by both the state of Florida and the federal government are extraordinary. And we're going to talk about today about the relief that's provided for you, as well as some other legal and business issues that you should be aware of. So without any further ado, I want to introduce Representative Davis, Daniel Davis, who's the CEO of the Jacks Chamber, to kick us off this afternoon.
Thank you so much, George. I know that we're having a little bit of technical difficulties, so if you're watching, you're probably not going to see me, so I had to call in. I just wanted to say a special thank you to Bill Adams and George Lemieux and the Gunster firm for bringing this opportunity to our citizens in Jacksonville. Many of you are members of the Jacks Chamber. Some may not be. If you aren't, we're one of the largest chambers in the country, and we've been honored for many, many years to serve the business community. And like George said earlier, this is unprecedented times, and we are trying to figure out ways that we can serve our community every day. And even if we have these difficult times, we believe that we can serve the business community, that we are going to recover, and that with the help of all of us working together, we can pull through. So I'm excited to have this opportunity to serve today on this webinar. I think it's going to be a great practical overview of what's happening in the real world and some tips for you to be successful. Our goal at the Chamber is to have a series of these webinars over the next several weeks and to delve into different subject matter as we do it. So once again, I'm looking forward to the discussion. I can't wait to have the question and answer time, because I think that's going to be very informative for our members, and we appreciate you all participating in the webinar today. Thank you, George.
Thank you, Daniel. And now I'd like to turn it over to Bill Perry, to Bill Adams, who's the managing shareholder of the Gunster Jacksonville office, who is we can credit for making this all possible today.
Thanks, George. Hi, everybody. I'm Bill Adams. Like George just said, I'm the managing shareholder of Gunster's Jacksonville office. Thanks for joining us this afternoon. Daniel, thanks to you and the Jacks Chamber for partnering with us on this webcast. Now, while George mentioned others are going to speak to the state and federal COVID-19 response and to some more industry-specific topics, I'm going to talk briefly about Mayor Curry's recent order relating to business operations in Jacksonville. Now, most of you probably know by now that Mayor Curry signed Emergency Executive Order 3 on March 23rd, which followed the original declaration of a state of emergency on March 13 and some well-publicized limitations on bars, restaurants, and places of assembly, as well as his order closing the beaches to public access. Now, you can find the text of all of those orders on the city's COVID-19 response site at www.coj.net /recovery resources. Now, Emergency Order 3 is simple in its wording, and it puts the focus at the individual employee level to determine what action you should take as a business manager or owner. The order essentially directs business management to inventory job functions, and where a particular function can be performed remotely and is not essential that the employee be in the workplace, the employee should be allowed to work from home. Now, plainly, not all jobs can be done from home. If I own a construction business, my tradesmen and women can't do their job from home. But that's not necessarily true for my bookkeeper or my receptionist. In that case, the carpenters would need to come to work, but maybe I would send my bookkeeper home with a computer to do his or her work. As the employer, you need to look at each employee differently and have a discussion with them about what they can and can't do from home to perform their jobs. Now, I would encourage you to document these discussions and the basis for your decisions as to each employee. There's not yet a definition for what is an essential employee, which is a term used in Mayor Curry's order, but you should use common sense and be prepared to explain your decision. Again, make this determination individually for each job function. And obviously, not everybody is essential. Where work can be performed from home and the employee's presence at the business is not essential, the business is required to facilitate working from home to the best of its ability. Now, again, that means different things for different job functions. It may mean forwarding calls to a cell phone. It may mean sending a computer home with your employee. Again, document your efforts. If you can't accommodate a non-essential employee and they have to come in, document your efforts to try to accommodate them and explain why they didn't work. Now, the order also has a piece that deals with for those employees who continue to come to work. And it requires the businesses to accommodate social distancing, and it mandates that employees be 6 feet apart unless their job precludes that distancing. Again, this is also individualized to job function. Going back to my example, my carpenters might ride together in a truck to a work site, but then they can separate when they arrive. You should also consider, as part of your individual job inventory, creating workplace policies for your various job functions. Again, one size does not fit all. Now, there's been in the Florida Times Union and other media outlets reports that the mayor's office is currently cataloging reports of violations of his order. My understanding from the mayor's office is they will begin enforcement efforts with those businesses that have done nothing to comply with the order. So if you document why employees' functions are essential or why they can't be remote, and then you have social distancing guidelines for your employees, you ought to be well equipped if you receive a visit from code enforcement. Importantly, the mayor's office is working on best practices guidelines, which should release next week. So be on the lookout for those. Now, in his briefings, Mayor Curry has repeatedly said that this is not a business shutdown order, and the language of his order does not mandate closures relative to general businesses. But that said, I think a theme of his briefings have been to ask people and businesses to comply with requirements so that stricter steps don't have to be taken. Now, obviously, we're seeing shelter-in-place orders being put in place in some jurisdictions, typically with some language requiring all non-essential businesses to close. Now, again, just like with employees, there is no universal guideline for what constitutes an essential business. So if you reasonably believe that your business is essential, then you ought to be ready to explain why. The mayor's office is encouraging businesses to get out in front of government on this issue. So if you think your business is essential, the mayor's office asked me to tell you to send an email to Jordan Ellsbury in the mayor's office at jelsbury@coj.net. That's JELSBURY@coj.net to explain your thinking. Again, while they don't presently have plans to increase the restrictions at this point, it's better to begin working to get on the essential business list in case that does happen, rather than have an order come in place and then you're scrambling to try to get on the list with everybody else. I think I've probably used all my time, George, but if anyone has questions, please be sure to send them in the text and I'll try to get them answered. And if there's anything we here in Jacksonville can do to help your business's efforts to comply with this or any future orders, please don't hesitate to reach out. Back to you, George.
Thank you, Bill. Great job. And really critical to comply with those orders. These orders are changing. We're monitoring them around the state. And I can tell you that the orders vary from jurisdiction to jurisdiction. So please check in. We're going to be posting and have been posting these orders on the gunster.com/COVID-19 website, and we'll be happy to try, as Bill said, to navigate that for you. Let me go now into my portion of the presentation where I'm going to talk to you about the federal legislation and what's happened. As we've been on the phone, the United States House of Representatives has passed the CARES Act that was previously passed by the Senate, and it's off to the president. It is a $2.2 trillion package. It is an extraordinary amount of spending. To give you some sense of proportion, that is about as much money as the federal government spends in a year for non-discretionary spending, and this money will be spent over the next couple of months in addition to what's already budgeted. There are several really important provisions concerning your businesses that I want to cover right now for you, but we also are going to have an alert that will be on our website today, which will go into all of these sections in detail, and you'll be able to access more information than what I can provide to you in the short time that we have together. The first part of the legislation that I want to direct you to is the Paycheck Protection Program. This is a $349 billion federally guaranteed SBA loan program. It's going to expand the current SBA loan programs in terms of the size of the businesses that are eligible. It's going to ease the loan terms. It's going to make all or a portion of the loans forgivable, and I want to emphasize that. And if you comply with the terms of the CARE Act, potentially the money that you receive as a loan will not be a loan, it will be a grant that you will not have to repay, which is a huge change in the way that we've done these loans. It's going to provide incentives for lenders to simplify and accelerate also the making of these loans. So who can get these loans? Any business that is either for-profit and importantly also not-for-profit is eligible as long as they do not have more than 500 employees. Now that 500 employee restriction has some caveats to it. If you have multiple locations, you can have more than 500 employees so long as you don't have more than 500 employees in any one given location. There's going to be other exceptions for other industries too, so you'll have to check the SBA rules, and we can guide you on that because some industries are going to allow to have bigger size companies. The company has to be operational as of March 1st of this year, and has to have employees on the payroll for whom it paid taxes, or independent contractors are going to also qualify under this. Under the loan terms, there is a maximum interest rate of 4%, and the loans will be equal to 250% of the employer's average monthly payroll. 250% of the employer's average monthly payroll, with a maximum of $10 million per business. The loans will be for the payment of payroll, paid sick leave, medical or family leave, cost of group health care benefits, insurance premiums, mortgage payments, rent, utilities, debt obligations incurred before the covered period. And it will be limited to employees that have compensation of $100,000 or less. The loan forgiveness part that I mentioned earlier, the amount by which the loan will be forgiven is equal to the amount spent by the business during this 8-week period following passage. The president's going to sign this presumably today or tomorrow. During that 8-week period for payroll costs and qualifying mortgage, interest, lease, and other utility payments, the loan forgiveness will be reduced proportionately if you let employees go. A reduction in employees where their compensation is in excess of 25% of the total compensation will decrease the amount of the loan that will be forgiven. The goal that Congress is trying to achieve here is to keep everybody employed during this difficult time. So that's an extraordinary piece of legislation. There are SBA loan providers. I texted with Senator Rubio just a few minutes ago, and by the way, we can thank Senator Marco Rubio because he was the chair of the Small Business Committee in the Senate. He wrote this legislation, and he told me that there are more than 800 existing SBA certified lenders, including banks and credit unions in the state of Florida. Those are the folks who are going to be doing the loans. There's other relief. There's economic injury disaster loan programs. This will loan up to $2 million to help small businesses with their financial obligations because of the disaster. This is an expansion of a current program but it waives a lot of the restrictions that the other program had, including a restriction where you had to show that you couldn't get credit someplace else. And it eliminates the personal guarantee piece of it, which is a huge deal. So those loans are going to be available also. There also is a bunch of tax relief that's available in this bill. This gets a little detailed, and you'll be able to see this information on our website, and we can certainly get a lawyer in our tax department to help you with it. But there is some significant tax credits that can be achieved for employers equal to 50% of qualified wages paid to employees who are not working due to the employer's full or partial cessation of business. There is a delay of payment on employer payroll taxes. That's also a piece of this. There's a change to the way net operating losses are accounted for, and a change to the way that the minimum alternative tax refund is accounted for. All this information is available, and we can guide you on it. There's also another bucket of money of almost $500 billion for severely distressed sections of the economy. This is geared towards larger businesses between 500 and 10,000 employees. The airline industry is the one that comes most to mind, but other businesses, including not-for-profits, can potentially apply for this. Think about a big not-for-profit like the Red Cross with that many employees. So that's another fund of money that is available. That loan program has not been set up yet. The Secretary of Treasury is directed to do that. We will keep you advised about how loans will be processed through that program. Let me finally say that there are two Florida programs, state of Florida programs. There's a Rebuild Florida Business Loan Fund that provides $40 million for loans. There is a Florida Emergency Bridge Loan Program that allows for businesses who qualify between 2 and 100 employees to get up to $50,000 in loans. You can get more information about these at floridadisasterloan.org, and we'll have that information on our website as well. So a lot there to digest. We will help you navigate it, but extraordinary funds to businesses in Florida and throughout the country to keep people working in this difficult time. I'd now like to take the opportunity to introduce our partner, Holly Goodman. Holly is going to speak about some of the changes that have happened in the past couple weeks in federal law concerning requirements of employers, paid sick leave, FMLA expansion, and government assistance. Holly?
Thank you, George. So the CARES Act that George was just talking about was technically phase 3. Phase 2, which passed last week, was the Family First Coronavirus Response Act, the FFCRA. It doesn't have quite the same acronym as the CARES Act. It makes it a little bit more difficult, but the FFCRA provides 2 different programs to protect employees who need paid leave in order to deal with issues that are arising based upon this current pandemic with the coronavirus. The first piece of it that I'm going to talk about is the Paid Leave Act, the Sick Pay Leave Act, for all employees of employers with fewer than 500 employees total. So that calculation for whether or not you have 500 employees total is determined at the time that an employee is seeking to take leave. So most companies are going to want to take a look as of April 1st, which is when the act goes into effect, to determine whether or not they're going to have to offer paid sick leave to their employees. So all employees of companies with fewer than 500 employees total are now entitled to up to 2 weeks of paid leave. For full-time employees, this is an entitlement of 80 hours total. For part-time employees, it is the average number of hours that the employee works in a 2-week time period. There are different ways to calculate those numbers. The Department of Labor has given some guidance on how you can make those determinations for part-time employees if those employees don't work a regular or set schedule. If they have a set schedule, then you use the average number of hours that they are typically scheduled to work in a 2-week time period. So this paid sick leave will now apply to both full-time and part-time employees. There is no minimum service requirement. So this applies to every employee, no matter how long they've been with the company, as of April 1st. It is not retroactive. So for many companies, they've seen employees who've been taking time off or have been required to stay home in the last few weeks. If those employees have taken time off, the pay is not retroactive. They're not entitled to be paid under this act for that time period, and they're still entitled to take up to their 2 weeks worth of paid sick leave under the new act starting April 1st. So there's two different sets of qualifications for when an employee may be able to take paid sick leave under the act. The first is for the employee's own care. So if the employee has been ordered to self-quarantine by a federal, state, or local governmental official, they're able to take paid sick leave for up to 2 weeks. If they've been recommended to self-isolate by a healthcare provider, an employee can take paid leave for up to 6 weeks or for up to 2 weeks. And if the employee is exhibiting symptoms of the coronavirus and is seeking a diagnosis, then they're entitled to take sick leave for up to 2 weeks of pay. If they use their paid sick leave for any of those circumstances to care for themselves, then it is paid out, those hours are paid out at their regular rate of pay. But it is capped at $511 per day, which is about the equivalent of $133,000 salary basis. So those are for if the employee is using it for themselves. The employee can also use paid sick leave if they are caring for another individual who is in self-quarantine or self-isolation, or if they are required to stay home because they have a minor child who is out of school or whose daycare is closed. If they use paid sick leave in those circumstances, then the hours are paid out at 2/3 of their regular rate of pay and are capped at $200 a day. In all of these circumstances, the employee is only permitted to take the paid sick leave if the employee cannot work or telework. So if the employee is able to perform their job at home and they're capable of doing so, then they don't get the paid leave. You can continue to make them telework. Now, the second piece of the Family First Coronavirus Response Act is an extension of the Family Medical Leave Act. This now applies to all employers with fewer than 500 employees, including small employers. This is unique because typically the FMLA excludes companies with fewer than 50 employees. But the emergency FMLA, this extended FMLA leave, applies to everyone as of right now. The Department of Labor will be issuing regulations that will exclude employers with fewer than 50 employees from these provisions if it would jeopardize the business as a going concern. Those regulations are still forthcoming. The Department of Labor has stated that they will put out specific criteria and that a company will have to document how they meet that criteria in their own records, but there will be no application process. So for all employers with fewer than 500 employees, their employees who have been working for more than 30 days, so 30 days is now the service requirement, are entitled to take an emergency family medical leave if they are unable to work or telework and they have a minor child who is home because their school or place of daycare has closed, place of care has closed. For that emergency family medical leave, the first 10 days are unpaid, but the employee can supplement with any paid leave they have available, including the emergency paid sick leave. After that, the emergency family medical leave is paid for the remainder of the FMLA period, which is a total of 12 weeks. So the first 2 weeks are unpaid. The next 10 weeks are paid at 2/3 the employee's regular rate of pay, capped at $200 per day. So the DOL is still putting out regulations. They are giving guidance on how to interpret these provisions and how they work with one another. They have provided a frequently asked questions page that was posted on Tuesday. It's been updated as recently as yesterday. They've posted the required notice posters on their website as well. So the DOL is a great resource right now to be able to find some quick answers on how the DOL anticipates interpreting these programs. Now, the final piece I want to point out for this is that as part of the Family First Act that was passed last week, there are now going to be tax credits for any paid sick leave that you're required to pay out under the Family First provisions. So for both the paid sick leave and for the emergency family medical leave, employers will receive a 100% tax credit for their payroll taxes, and that this will be on an immediate basis. So with that, I am going to turn things back over to George. And if you have any questions, please be sure to put them in the box and we'll see what we can do for you after we're done with our presentation. Thank you, George.
Thank you very much, Holly. That was really helpful. I want to turn it over now to Asghar Syed and Julia Holden Davis. Asghar is a shareholder in our Jacksonville office in business litigation. He's going to talk about force majeure or act of God clauses in contracts and the cancellation of events. And then Julia Holden Davis, who's a shareholder also in our Jacksonville office in our litigation group, as well as the co-chair of our construction practice, is going to talk about project delays, notice letters, and then how force majeure clauses apply to construction and permitting delays. So let me first turn to Ashkar, and then he'll turn it over to Julia.
Thanks so much, George. So as many of you likely know, a force majeure provision can excuse a party's contractual non-performance or delay under certain extraordinary circumstances. So I'm going to quickly run through how courts interpret and apply force majeure provisions. I'll also touch on, but not really get into any detail, of common law and statutory principles that run parallel to force majeure contractual provisions. But before we get into the weeds, let me make a couple of high-level points. This is a case-by-case analysis. It is deeply fact-intensive, and therefore, as a result, it's necessarily highly unpredictable how a force majeure dispute can play out. It really depends on the circumstances. So what are our takeaways? What we all should be doing right now is getting a hold of our material contracts, identifying the force majeure provisions that are in our material contracts, evaluating them, considering the likelihood that they might be brought to bear today in any of our business dealings, and also thinking about who is likely to assert force majeure. Is it us, or is it our contractual counterparties? The next step, to the extent we are all dealing with the shocks and the uncertainties that have arisen on account of COVID-19, we want to be negotiating mutually agreeable and predictable outcomes with our contract counterparties. The force majeure provisions in our contract are oftentimes the backdrop to these negotiations. This is happening a lot in event cancellations at the moment. The parties, whether it's a venue or the individual, the group that was hoping to host an event, they are pointing to their force majeure provisions. The parties might take very different positions on how those force majeure provisions might play out. But really what we want to be doing right now is negotiating with that backdrop an outcome that is mutually agreeable, whether that's a refund with a cancellation or a rescheduling of the event. Finally, if we have no choice, if in fact we need to rely on this force majeure provision because it is truly impossible for us to perform under one of our contracts, it's extremely important that we went through that negotiation process, and it's important that we documented every step of the way our willingness and our desire to mitigate any damages, any negative consequences of non-performance. So with that, let me get into the weeds a little bit. How do courts interpret and apply force majeure provisions? Here are the elements in Florida. The asserting party must show that the event, one, qualifies as force majeure under the contract, and we'll talk about that, was not foreseeable, could not have been avoided, that gets at mitigation of damages, and was the sole and proximate cause of the non-performance. We'll talk about each of those one at a time. The first question is COVID-19 a force majeure event under your specific contract? Now, what's important to understand here is that force majeure provisions are narrowly construed by the courts. The courts want to know whether a particular event was specifically identified in your contract. So the first question we're all asking is pandemic, epidemic, disease, a term like that specifically identified in our contracts? The next thing that we're going to look for is government action, particularly for purposes of events, travel, movement, or large gathering restrictions that might make a gathering impossible. The term that is in many, many contracts and that everybody is asking about is act of God. That's a very common term in force majeure provision. The fact is that there's no binding authority in Florida on whether COVID-19 coronavirus, a pandemic, is an act of God. There are good arguments to be made either way in legal scholarship. A lot of folks are talking about this, writing about this right now. In 6 months to a year, we might have a lot more guidance from the courts on whether COVID-19 is an act of God, but that assurance does not exist in any kind of binding authority in the state of Florida at the moment. The last point I want to make about contract terms is a force majeure provision can be drafted in a closed-ended manner or an open-ended manner. A closed-ended force majeure provision will say, here's a series of events that constitute force majeure. It's a complete and exhaustive list, and the analysis is reasonably straightforward. On the other hand, an open-ended contract might say that any performance is excused if an unforeseeable, unavoidable event happens, and then it might provide a series of illustrative examples of what that might mean. That shouldn't necessarily to you mean that you're going to have a clear-cut force majeure argument. Many courts have interpreted those open-ended contracts as still limited to the items that are specifically identified in your force majeure provision. They might give a little bit more breadth in interpreting those specifically identified events, but it doesn't mean that it's open-ended. Last point on contracts, you want to be very careful about notice provisions, any conditions proceeding to asserting force majeure, and make sure that you're keeping those in mind if you're going to get into a negotiation and assert your force majeure rights in that negotiation. Next point, foreseeability. I think it's reasonably clear that as of March of 2020, COVID-19 and its effects were not foreseeable. That analysis is going to change over time. It might not be the same analysis in October of 2020. Next, could the non-performance be avoided? This is absolutely critical. First and foremost, parties to a contract must perform to whatever extent they can. It is critical that you mitigate any damages arising from non-performance. And as we noted at the top of this, you want to be negotiating, you want to be documenting your willingness to mitigate. Finally, causation. Is the event the sole and proximate cause of non-performance? This is a high standard. The other side, if they want to fight your assertion of force majeure, is going to point to other causes that may have led to your non-performance. And the other thing you want to be conscious of is, are you taking steps prudently over and above what you might be required to due to government action? In an interest of protecting your workforce, do you shut down operations before the government mandated it? How is that going to affect your force majeure entitlement? So bottom line on these, there is some substantial risk on getting it wrong. The party that's asserting force majeure has the burden of proof. If a court ultimately finds that they didn't meet all of the elements, then that party may, if they took a hard and fast position on the front end, be found to have anticipatorily breached or repudiated their contract, and there's consequences to that. Last thing I'll say before turning it over to Julia, if your contracts do not include a force majeure provision, there are, as I mentioned, common law and statutory principles that might be relevant to your particular dispute. Impossibility, impracticality, failure of essential purpose. And there's also, in the sale of goods context, the Uniform Commercial Code, UCC, there are some impracticality concepts that are baked into that. So with that, let me turn it over to Julia, who's going to talk about force majeure more in a construction dispute context.
Thanks, Asghar, and good afternoon, everyone. I want to echo something that was already said, which is that this is a fact-intensive question, and it's definitely governed by the terms of your contract. That means it's a complex question for those of you that are running construction businesses or have multiple developments going on, because you're going to have to look at each of those individually. So the terms of the force majeure clause, what it allows, are going to be important. And then what specifically is impacting your project is going to be important. As George mentioned at the beginning, the rules are not the same across the state, and they're not the same across the country. So understanding what exactly is the impact that you're dealing with is going to be important as well, and that could very well change. Following the notice provisions is going to be important, and unfortunately that's going to mean you may end up doing more than one notice. You may end up doing a notice initially because of one executive order and then having to put in a supplemental notice. One of the things that may be helpful, though, on the construction side is we also have other clauses that could come into play and that you should be looking at in your contracts for relief. One of those is the suspension clause. There's often a clause in the contract that deals with what happens if a project is suspended and who has the right to do that. You should be looking at that along with termination clauses to understand if there are other things that you could be looking at to either mitigate risk or to try to recover costs that you may be incurring. Connected with that, we often have changes clauses as well that may speak to what happens when the cost of the work is impacted. You may have obligations to protect the work. If your site is shut down, you may still be responsible for making sure that it is left in a safe condition, providing security, or doing other things. So you need to dig into all of those different issues, not just the force majeure piece as you're considering what to do with the project. You can't do that all at once, especially if you've got multiple contracts. So one just practical thing to consider is sending a pretty generic notice and then following it up with more specific and contractually compliant notices, particularly on your larger or higher risk projects. To give you all an update on just what we're seeing in the city of Jacksonville right now, we are seeing projects move forward, but we are seeing them be impacted by what's happening. So for example, you can still apply for a permit, but the permit applications are being handled electronically only, no paper submissions. A lot of the agency lobbies and offices are closed, so no walking in and resolving things. We're still seeing responses, but they're slower. I think everyone is working through what it means to work remotely. We have seen some inspections be suspended. So right now, residential and structures that are occupied, so occupied residences, they are not inspecting. They have not waived the inspection requirement, so you still have to get the inspection, but you can't do it right now. So if you've got projects, you need to be watching those. In South Florida, we're seeing that start to impact projects now, but make sure you know what you need inspected, whether you can get that inspection, and follow up on those pieces as well.
Okay, Julia's going
with that, I'll send it back to George.
Yeah, go back to the microphone.
And actually, let me come back in and I'm going to send it to someone else. I think we're going to move straight to insurance, and one of our other colleagues is going to speak to that.
Thank you, Julia. This is Stephen Richmond. I'm in our West Palm Beach office, and my colleague Tim Daniger are also going to be speaking with you this afternoon about some of the insurance coverage issues that are arising out of this COVID-19 crisis. And I will start by saying, as many of you may know, the specific language of your policy is going to be critically important. A few of the coverages that we're going to discuss today are: one, business interruption coverage, and two, contingent business interruption coverage. These are generally coverages that are available to provide relief and reimbursement for lost business income and extra expenses that are incurred during the period of restoration. A couple very critical points on these coverages. It's not as simple as, hey, my business is earning less, and so therefore I want to make a claim. These coverages arise out of fire losses, basically, where think that your business has a fire, you're shut down, and you cannot operate. So most of these policies require a direct physical loss or damage. Is the presence of a virus in the property itself considered a physical loss or damage? The general trend in the case law suggests the answer is no. However, there are some cases which have pushed the boundary, and those cases are being discussed among policyholder side lawyers and insurer side lawyers today, as we expect a number of claims to arise out of this crisis. You may, on your policy, have a specific exclusion for pandemic or virus-related losses. You know, this is certainly the largest and most unprecedented health crisis in terms of a virus we've seen in a long time, but insurers actually drafted an exclusion in 2006 following the SARS episode. And SARS is actually a form of coronavirus, and so many policies may have what's called the ISO virus exclusion. It's going to be very difficult to bring a business interruption claim with that exclusion attached to that endorsement attached to the policy. There's also something called civil authority coverage, which again generally provides some business income relief if there is an order in place preventing access to your business. Now, many of you may be thinking, there are all kinds of shelter-in-place orders out there that are not allowing people to visit places of business. Again, the devil's going to be in the details, and what does the policy language say? Many of these civil authority coverages require that the covered cause of loss happen before the building is shut down. Again, think about a fire loss. First you have the fire, and then the building is shut down. Then comes the order, perhaps from the fire marshal, not allowing anyone to go inside. These civil authority orders may also have a physical damage component. Again, just like we discussed in the business interruption context, is the presence of the virus in your building considered a physical loss or damage? Quickly on event cancellation policies, generally voluntary cancellation of an event is not sufficient to trigger coverage. There must be some kind of legal or physical impossibility. You must try to reschedule generally, and some of these policies have a communicable disease endorsement that, depending on your premium, may provide coverage or may not. On the workers' compensation side, very briefly, typically there is a work-relatedness requirement, meaning not only you can't just have received or contracted the virus at work, it must be part of the scope of your work. Think about a healthcare worker, a lawyer or an accountant who goes to work and acquires the virus. That likely would not be a workers' compensation covered claim because it has nothing to do with the lawyer or the accountant's work. We have already seen some lawsuits filed throughout the country on business interruption. The first one was filed in Louisiana. And so we are monitoring. I'm told another lawsuit has been filed in Texas. I'm not aware of any Florida cases yet filed on this issue. Interestingly enough, some insurers had previously offered pandemic coverage. They are likely not writing that now and will wait until this pandemic passes, but it was an available coverage previously. There have been a few significant state responses. The Florida Office of Insurance Regulation has not taken any very drastic measures to date on the property side. But for example, New Jersey had proposed a law to essentially require property and casualty carriers to cover coronavirus-related losses. That has been withdrawn, and there are also significant constitutional problems since those coverages were likely excluded by many of these policies, and you'd be asking the insurer to cover something they never agreed to do in a contract. The New York Department of Financial Services has directed insurers in the property casualty sphere to send their policyholders a letter explaining the scope of the coverage. This is fairly unprecedented because these insurers don't have any facts based on a specific claim. We are not sure if other states will follow this lead. I watched an insurer side webinar earlier today, and I'm told that Ohio and Massachusetts have entertained similar legislation that was proposed in New Jersey. I'm going to go ahead and send it over to my colleague, Tim, but we are available to answer any questions and appreciate you attending today.
Thank you, Stephen. I'm Tim Danninger. I am a shareholder in Gunster's Jacksonville office, and I'm just going to provide 3 takeaways on the insurance coverage issues that Stephen just discussed. The first and probably most important is to go and gather and get copies of your policies and discuss all of your insurance policies with your agent and lawyer for any and all losses or potential losses. And it's important that you do all insurance because policies vary in language, and where one may not afford coverage, another may. So even if you read in the news there's no coverage for business interruption, it's important that your agent and your attorney have the opportunity to look at your policies to determine where certain language may be missing or may be left out of your policy that makes it unique. As part of this discussion, then, you also want to notify your agent in writing of your losses. And you also want to ensure that there's notification of all your carriers, including, of course, umbrella and excess carriers for those losses as well. The second takeaway would be to try to avoid damages where possible. If there is coverage under most every policy, you will have a duty to mitigate your losses, meaning that you must take reasonable steps to minimize or reduce your losses where possible. And the third takeaway is a pretty simple one, but this is a good reminder, is use this as an opportunity to review your entire risk management portfolio with your agent, broker, lawyer, speak to someone. If you need assistance, you can speak to us. But on the coverage issues, there's a lot going on right now. The states are trying to find coverage where they can, and insurers are going to be seeking to enforce their policy language. So these are some developing issues that will continue to evolve over the next few weeks. So thank you for your time. Back to you, George.
Tim, looks like George may have had technical difficulties again, but we've got a bunch of questions. I think this is where we can move into that stage of our presentation. So, Holly, take this one for you. Can you go into a little bit about the qualifications for forgiveness under the Paycheck Protection Loan Program? And can you advise as to whether a company can get the same benefit of forgiveness if they don't need to borrow the money to get the forgiveness?
That's actually George. George is the one most familiar with the CARES Act today. And so I think that if we do get him back on the line, that I think that would be an appropriate question for George to field.
Well, my mistake. Well, here's one for you then. I think this one's for you. Regarding the ER paid sick leave, how will the employer be reimbursed for an organization that's tax exempt?
That I can take. So there were actually a couple of questions that have asked about nonprofits and how they're going to be able to take advantage of those tax exemptions. And what the Paid Sick Leave Act, the Family First Coronavirus Response Act, did was that it actually made those tax credits apply to payroll taxes. And so although nonprofits are exempt from the vast majority of taxes, they do still pay into the payroll taxes on behalf of the employee wages. And so the tax credits are going to come from that perspective.
Great, thanks.
Bill, this is George. Can you hear me?
Sure can, George.
Okay. Repeat for me, if you would, that other question so I can try to answer it.
Sure, let me find it. What are the qualifications for forgiveness under the Paycheck Protection Loan Program? Also, can a company get the same benefit of forgiveness if they don't need to borrow the money in order to get the forgiveness?
So on the last piece, they don't need to borrow the money, but there are some specific restrictions. They have to use the money for paying for payroll costs, mortgage interest, lease, and utility payments. There's also provisions for how much of the staff you keep on payroll. So if you reduce the staff by more than 25%, the amount that is forgiven is also reduced. So this information will be on our website at gunster.com/COVID-19, and you can provide some follow-up on that.
Great. Asgar, does force majeure apply to nonprofits who enter into contractual agreements with corporate partners to accept support interns financially? And should those nonprofits anticipate withdrawal from those agreements based on force majeure?
Thanks, Bill. So let's narrow the issue just a little bit. First of all, whether you're a for-profit or not-for-profit entity is not going to affect the analysis. It's really just a question of contract. If your contract contains a force majeure provision, then we talked about some of the nuances earlier about what we're going to want to look at. What are the specific events that trigger that provision? And then in this case, the accepting or supporting of interns financially. The bottom line question here is going to be impossibility or impracticality. Is on account of the events that are occurring in the world, and whatever the triggers are in your contract, are you not able to follow through on whatever that contractual obligation was? One of the points that I should have mentioned in my presentation earlier is that the law is clear that if performance becomes unprofitable or economically burdensome, on account of events that may be captured in your force majeure provision, that does not forgive performance. Just because it's no longer a good business idea to do something, that's not going to meet the threshold. You really want to be able to show that you are unable to follow through on whatever that contractual obligation was. And just to reiterate from earlier, you really want to get on the phone with your contract partners and see what you can work out and make sure you document all of those efforts before pulling the plug.
George, are you back?
I am. Thank you. We have some other questions that I want to go to. There was one question about estate planning and whether or not you should make any estate planning considerations in light of what's going on. This is a great time for you to check with your estate planning lawyer about making sure all your documents are up to date, up to speed, and in light of any new tax developments that are out there. So I would encourage everybody to make that contact with your estate planning lawyer. If you don't have an estate planning lawyer, we'd be happy to help you with that. We had another question about, will the Paycheck Protection Program be administered under the SBA 7A process? And the answer to that is yes. But as I mentioned earlier, they've changed a lot of the requirements, loosened a lot of the standards. So all this will be provided on our website. If you didn't catch it earlier, it will be under that program, though. Let's go to some of the other questions that we've received. I think, Holly, did you speak yet to, does the FMLA extension apply to full-time employees only?
I have not, but I can answer that, and that is it does not. The FMLA extension, so only the provision that provides for paid leave for parents who have minor children, it is applicable to any employee who's been working 30 days or more. And so there's no restriction there on part-time versus full-time.
Great, thank you. Some other questions that we have that have just come in. If we provide working from home and do not require a certain number of hours for an employee and they have kids, can they still take the LOA for the child care reason?
They likely would be able to. So the only requirements that are under the Act right now are that an employee notify you that they are unable to work or telework because they have a minor child at home who is out of school or out of their place of care. So if the employee came in and said, I can't work because my elementary school child is home from school right now, then they would be entitled to use that leave.
There was a question about borrower certification requirements for a loan under the Paycheck Protection Program. Again, those requirements have been loosened from what they were. And there was a question specifically about how do we evaluate the requirement to certify that a loan is needed to continue operations. I think that you're going to be able to do that based upon what's happened locally. As Bill mentioned, you've got this closure order. And then also you're going to be able to do that by showing your economics. Some of these programs are for businesses that are shut down. Some of these programs are for businesses that have had a significant loss. Others are for all businesses. So there are different buckets that you can fit into, and we can help guide you as to what would be the right one based upon your size of your business and the condition that you're in. Bill, there's a question I want to turn over to you that came in, which was hearing that city officials were entering the businesses in Jacksonville and shutting down operations, also concerns about threats about turning off electricity to buildings. Can you speak to what Jacksonville is doing to enforce its closure order?
Sure, George. I think there's a lot of rumors going around right now. And while the city is cataloging reports of businesses not complying with the mayor's executive order, my understanding is that they have not yet begun enforcement. Now, I do think that Mayor Curry said in one of his briefings over the last couple of days that, condemnation of a building or turning off utilities could be a remedy that might be available to them in the event that enforcement was needed. But having spoken with the mayor's office, the order of affairs in terms of enforcement is going to be that code enforcement would visit a non-compliant business and essentially engage in a dialogue to try to understand what was going on. In a case of just, absolute obstinate non-compliance, well, that's going to draw a certain response from the city. If someone is not complying because they don't understand or because they have tried but are falling a little bit short, that's going to draw a very different response from the city.
And Bill, I'd like to jump in on that. This is Daniel. And I think that you've really dialed in here. It's really a common sense approach to what your workforce has to do. And so, for example, my employees at the chamber all can log in from home. They can all do their duties from away from the workplace. And you could have a car dealership who obviously they cannot have all of their employees at home and still sell cars. I think everybody just needs to have common sense, try their best to comply, and ask questions when you don't know for sure.
I think that's really, really sound advice, Daniel, for everybody. And, you know, my conversations with the mayor's office suggest to me that that's the exact approach they're going to take with regards to enforcement. You know, not draconian, not coming down on people, but a very common sense approach.
And once again, Bill, when you're, I would just say this is very practical information. When you do have to have your employees in, make sure they're 6 feet apart. Make sure you're trying to socially distance, and do everything you can to keep them safe. I think everybody wants the number one, health and safety of their employees.
Couple more questions. Under the Payroll Protection Act, it excludes employees above $100,000. That's correct. Only applies to salaries of $100,000 and lower. There was a question about if I have a full-time employee now was already considering moving them to part-time, should I do this prior to April 1 to minimize risk? March 1 is the time frame that they're looking at, and it's not that you can't let any individual go. They're going to take a deduction on your ability to have the loan forgiven if you're over 25% change in your staffing. So one employee, best we can tell from the law as written. Now, I want to caveat that on all of this, there are going to be regulations and guidelines that are written by the agency in charge. So for this particular one, the Small Business Administration is probably going to provide further clarification. So we're giving you the best advice we can give you on a bill that has not even been signed by the president yet, going off the language that we have. So you'll have to stay updated. But as of now, it's the 25% mark that matters. So we have a few more minutes on the call now. We're coming up on the hour, but we've extended the call for a few minutes. So we're going to try to get to more of your questions. And I'm just looking at them here to make sure that they're ones that we haven't already answered. There was a question about the defense industry and whether, you know, the fact that companies are not getting the contracts and that the businesses are slowing down, and asking us to share insights on Department of Defense work stoppages. One of the things that's in the bill, there's this whole section which I mentioned for targeted industries that are really being impacted, and industries that are in national security are going to get $17 billion. So I think that defense industry related companies are going to receive special consideration, and that should hopefully free up any work stoppages that you see out there based upon the availability of that funding.
George, this is Julia. Can I add one thing to that?
Please.
That there's also projects right now on the federal side that are having the opposite experience. So this is another thing to make sure you know what's going on with your project. The government has prioritized some of the defense-related contracts, which means that they can direct people to prioritize that work. They can require them to keep working, even though we've got other more local issues that that may seem, particularly on Department of Defense work, but also on federal contracting specifically. This is also a one size does not fit everything. We actually have some contracts that are being accelerated because they're trying to get them done for various reasons. So keep an eye out, I think, on both sides of that issue, both being stopped, but also potentially being told to go to work and make this the most important thing you've got.
Very good. There's a question about insurance, and maybe Tim or Stephen can answer this. If you are one of the many businesses that's been ordered to shut down or significantly curtail your operations, what do you need to check in your insurance policy?
Oh, this is Stephen. I think you first need to look, do you even have number one, do you have any pandemic or virus-related coverage? Number two, do you have any civil authority extension of coverage in your business interruption policy? As I understand it, your business interruption coverage would typically be in your commercial property policy, although it could also be as a standalone policy or as part of your business owner's policy, which is generally a combination of both CGL, commercial general liability, and commercial property coverage. But if you're talking specifically about closure orders, then I think civil authority or perhaps ingress and egress grants of coverage would be a good place to start. Tim, any thoughts that you have?
No, I think that really is the areas, the business interruption coverage and the possible exclusions that go with it. There are other types of coverage that may apply in different circumstances, but for that, that's going to be what you're going to want to look to.
Okay, we're going to wrap up. I've got a couple more questions here. There's a question about the SBA loan program approval for forgiveness for payment of qualifying expenses, including existing debt, asking what type of debt that applies to. We don't have clarity on that, if there was anything that's excluded from the type of debt. So as, again, regulations are provided, the goal of Congress is to make this as broad as possible. So hopefully they will not create limitations, but we'll have to see what happens as the SBA actually starts to administer this. The way this is going to work is you're going to get your SBA loan from the credit union or bank here in Florida. As I mentioned, Senator Rubio has told me that there's more than 800 in Florida. They're going to have some of the particulars about these loans, and then we're happy to work with you to try to help you secure that loan and navigate any obstacles that get put in the way. Last questions. Do all healthcare clinics follow under the SBA lending program? There's no exclusion that I've seen on healthcare clinics. They're really there's no industry or business type that has been excluded. There was some language about businesses that were receiving Medicare payments, and I believe that was eliminated from the final legislation. So I do not believe that there is any barrier to healthcare clinics following under the loan program. And then finally, on paycheck protection loans, question is the wage capped at $100,000? And again, that's what the legislation says, that it has to be under $100,000. So that's all the questions that we have for today. I hope that this was helpful. This webinar will be available on our website at gunster.com/COVID-19. I want to thank Daniel Davis and Bill Adams and the Jax Chamber and all the members again and all the Gunster team for being on this call today. And hopefully you found this useful and helpful. This is a difficult time in Florida. We are going to get through this. We're here to help you get through it, keep our businesses going, keep our employees working, and do the best we can for our families as we progress through this difficult time. Thank you so much for participating today in the webinar.
Thanks, George.